Hello everyone and welcome to this new episode of the Privacy Rules Privacy Espresso series. Today I'm going to update you on the recent adequacy decision taken by the EU in relation to two specific countries that are here represented together with me by our experts that are respectively Argentina, for which we have Mariano Peruzzotti from the law firm OJAMBF, exclusive partner of the Privacy Rules Alliance, and Uruguay, for which we have Manuel Pittaluga from the law firm Pittaluga Abogados, that is going to give us an overview as well on their position in respect of this decision that I think was very relevant. I would like to very quickly give the floor to our speakers of today, starting from Mariano, as I know that Mariano has also been writing an article on this topic. So Mariano, you can briefly give us an update of what we are talking about for the ones that don't know what an adequacy decision is.
Sure. Thank you, Alessandro, for having me here. As you may know, according to Article 97 of the GDPR, the European Commission must periodically review the adequacy decisions taken before, and this review must take place every 4 years. The purpose of this review is to determine whether a country or a territory that has received a previously adequacy finding will continue providing an adequate level of protection for personal data. This review was postponed because of the European Court of Justice, European Court of Justice in Schrems II decision to consider the judgment and all what was involved with that specific decision. So recently, the European Commission analyzed the specific case of each jurisdiction, including Argentina and Uruguay. And in both cases, the European Commission took the decision of continue or keeping or maintaining the adequacy decision taken for both countries. In Argentina, it was in 2003, and in Uruguay, I think Manuel probably will confirm in 2012.
Yeah, thanks a lot, Mariano, and thanks a lot, Manuel, for confirming. As you are saying, in this case, we're speaking about confirming an adequacy that was already existing before. So my first question to you is exactly related to the path from the first adequacy to today situation. In your respective jurisdiction, do you think that the path to keep, let's say, adequacy level was something complex that has required your country to make, many updates? So this is more or level similar to the level we were having in the past. Maybe we can start with you, Mariano.
Okay, sure. Yeah, well, as I mentioned before, the adequacy decision was taken in year 2003, so almost 20 years ago. So many things have changed. In that sense, and as pointed out by the European Commission, I think that Argentina has made solid efforts to keep the adequacy decision. In that sense, the European Commission highlighted the fact that we have now a new data protection authority, which has more independent, or it's more independent from the executive body. And also there are many new regulations that are kind of similar with the provisions of the GDPR that were incorporated by regulatory efforts taken by the Argentine Data Protection Authority. And also, which is very important, Argentina has strengthened its international commitment in the sense that Argentina joined Convention 108 and 108 Plus, which is very important. So basically, I think that in the case of Argentina, many things have changed since the adequacy decision in year 2003.
What about Uruguay, Manuel?
Yes, as Mariano says, the first adequacy decision was in 2012. From that time, different things changed, and Uruguay made different efforts and reforms to the law and to the decrees, etc., to continue to be adequate. This confirmation reaffirms Uruguay regulation that was modernized from different reforms, confirms our Uruguay compromise to be adequate to European Union and GDPR regulations. Okay, our key data privacy law was from 2008, the 18331. After that, for example, there was a law 19670 that made some kind of reforms, as for example, expansion of the territorial scope, proactive responsibility, impact assessment, privacy by design and by default, and also the figure of, as we say here, the delegado de protección de datos, okay? And also, as Mariano says, that happened in Argentina, in 2021, Uruguay enacted the law 19948 that approved the protocol 108 plus. The original 108 was approved in Uruguay in 2012. I think, Mariano, that Uruguay was the first country outside Europe to approve the protocol 108. And now in 2021, we approved the 108 plus. And then there was a number of resolutions by the Data Privacy Office, the Unidad Reguladora y Control de Base de Datos in Uruguay, that, for example, the last one, the 70/23, that expanded the list of adequate countries to Korea and also includes the European Union and US data privacy framework, okay, in 2023, and also some obligations, new obligations to the organizations to transfer the data privacy.
Thanks a lot, Manuel. And I think that it's clear that there were actually efforts on both sides
Yes.
to, keep path with compliance. Of course, also the EU was evolving a lot, so it's nice to hear. And of course, as Manuel was saying, the Convention 108 plus was definitely one of the key elements for both your countries, because also Argentina, of course, did join it. And I heard a lot of Mariano for Argentina, the fact that the creation of a DPA is always considered as something very relevant for those type of steps. In this regard, my question would be, were you expecting this adequacy decision to come quite easily, or there were some points that you think could have been an issue for the adequacy? And this time I would start from Manuel.
My answer is going to be short, because yes, Uruguay was expecting the resolution. Our government thought that all of these changes and reforms I was telling you before were very good and showed that Uruguay was adequate, and it has the framework and the law and the regulations adequate to have this resolution. So yes, we were expecting it.
What about Argentina, Mariano?
Well, Alessandro, local authority was quite confident on keeping the adequacy decision based on the developments I mentioned before. However, and this is very personal, there was one important aspect, according to my point of view, that made us unsure, I will say. Basically, our law is outdated. I mean, it was passed 24 years ago. Argentine data protection law was enacted in year 2000. So, and no relevant amendments have taken place over the last almost 25 years. And this is something that was highlighted by the Commission in this recent decision, in the sense that they will expect that all these regulations approved by the Argentine Data Protection Authority, such as, for instance, the obligation or the recommendation, at least, of implementing binding corporate rules, or how to use binding corporate rules, or the data privacy impact assessment, and so on and so forth, will be included in a future data protection law. We have, as I mentioned in a previous Privacy Espresso, I mentioned there is an important bill that is being considered, or we expect to be discussed in the future. And this is something that was mentioned by the European Commission in its decision.
Great. Thanks a lot, Mariano. And I will keep moving with you for my last question in this regard, that is like a look forward to the future after this adequacy decision. What does it mean for business, and do you expect further steps? You already mentioned one on the government side for keeping this part of complying with privacy or enhancing your privacy law as everyone is doing right now.
Yeah, sure. Well, you already mentioned it. It's for any country that obtain the adequacy decision, it's very important, not only from a business perspective, but also for the privacy atmosphere. Obtaining this decision is well considered by the privacy community. It reveals that Argentina, as in the case of Uruguay, are both still being considered as part of the country that respect privacy and personal data protection as a fundamental right, and that have made good efforts to strengthen the safeguards. And from a business perspective, it's very important because we live in a global community. Economy is very important for both countries, and the idea of not having any boundaries or restriction to transfer information from one country to an affiliate, or from one company in the European Union, based in the European Union, to an affiliate or a service provider in Argentina or Uruguay, it's very important. At least we have seen this over the last 20 years. And finally, to conclude, I would say that it is expected that the Commission will conduct a similar review within 4 years. So it would be very important for Argentina to have a new law enacted by the time that the Commission starts this additional review, this new review.
Perfect. Thanks a lot, Mariano. And Manuel, what for Uruguay?
Yes, for Uruguay, this decision demonstrates the Uruguay commitment to be or to stay at the forefront of international trends in data privacy, okay? And for a very small country as Uruguay, this is very important, okay? As for our image as a country, and as Mariano says, for our politics in data privacy, and also because of business. These kind of decisions and these kinds of measures from important as Europe. For us, it's very important to do business without barriers and to transfer data from our companies to Europe and other countries. And for us, it's excellent, and our authorities are very happy with it. Okay. In the future, I can give you an answer right now. Maybe if you let me some weeks to talk with an authority, maybe I can present a very detailed report about it, about what Uruguay is going to do in the future. Here, we have this year we have a change of government. So in these countries, Mariano, when a government changes, the politics and the ideas also change. So
of course. This makes a lot of sense, and this is actually something that is happening all over the world. I was speaking this morning with our members from India that are facing a little stop in their process because there is new elections. So they have to wait a bit more probably to see how this will develop. In general, what we see is that there is an interest in recognizing privacy as a right. So in general, it may be different, the approach, but both Argentina and Uruguay at least are countries that are investing on it. And of course, this means rights and then business, as Mariano was underlining. We ran out of our time, so I would really like to thank our listeners for being with us today, and I look forward to meet you all with our next Privacy Espresso. Thanks a lot again, Manuel and Mariano.
Thank you very much.
Thank you, Alessandro. Bye-bye.